Wanu. Uh, this is the latest news from Ripple, the Ripple's team. Okay, the Ripple team have responded to the SEC's fair notion. Okay, so let's go through this. Kellogg, Hanson, Todd, and Rigel and Frederick PLLC. Okay, Washington DC. Okay, so April 13th, 2023. That was last night. Honorable, okay, Annalisa Torres, United States District Court, Southern District of New York, RA SEC versus Ripple Labs Incorporated. Okay, here we go. Let's start this. Okay, dear Judge Torres, defendants Ripple Labs Incorporated, Bradley Gardenhouse and Christian A. Larson, collectively, the defendants respectfully respond to the SEC's notice of supplemental authority, which asserts that SEC versus Commonwealth Equity Services. This was the case that the SEC won last month. LLC number 1-199CV. Okay. Uh, okay. Actually, it was April 7th, 2023. Okay. Uh, an out of circuit, unpublished district court opinion provides additional authority for rejecting defendant's fair notice defense. Okay. In Commonwealth, the defendant adduced no compromised evidence supporting its defense that market participants lacked fair notice of an obligation to disclose economic conflicts of interest. Under the Investment Advisors Act of 1940, it merely quoted SEC guidance and presented a paid expert who opined that he believes in respect that the guidance did not require certain disclosures. Okay, see Commonwealth 223 paragraph. Okay, here. Um, Here, by contrast, there is abundant evidence, including extensive factual evidence from the SEC's own files and its common communications with third parties, showing that reasonable market participants trying to understand what the SEC would permit or prohibit concluded that the defendants' offers and sales of XRP were not investment contracts and told the SEC so. See, there is no abundant evidence that the SEC was not only aware of this widespread regulatory confusion, but helped to sow it by repeatedly offering and then disclaiming vague guidance that differed from the Howey test. The clear directive from Commonwealth 2023, which is April, right, at 9 is absent here, okay? Moreover, in Commonwealth, there was no dispute that the Investment Advisors Act applied to the defendant's conduct and required the defendant to disclose economic conflicts of interest in this case. The threshold issue and source of widespread regulatory uncertainty is whether the Securities Act even applies to to defendants' offers and sales of XRP. It does not. Okay. The SEC's boast of the unbroken chain of district court decisions rejecting fair notice defenses on summary judgment in SEC's enforcement actions is irrelevant. Uh, the court has already rejected the SEC's reliance on these cases. None of none of those other cases dealt with XRP, and the facts defendants abduced in support of their fair notice defense. Uh, the closest case, Upton, which the SEC excludes from its list because it is an appellate decision, is binding precedent and ruled in favour of the defendant's fair notice defence. This court should do the same, and Commonwealth does not change that. Respectfully submitted, Michael K. Kellogg, um, on Washington, D.C., uh, Counsel for Defendant Ripple Labs. Okay. That's the news today, guys. The Ripple responded to the SEC's stupid claim. Okay, and this is proof right here. You know. Okay, guys. Uh, thanks. Thanks for watching. Anyway, I will keep you updated of any news I find later today. Okay. Thanks. We just have to wait. We just have to wait for the judge's decision now. So, she'll probably read through this um, today, Friday. She may have already written her ruling, but she'll probably go skim through this. Probably take her about 20 minutes, and she'll probably just throw this out because this has nothing to do with Ripple and SEC case, because it's got nothing to do with XRP. XRP is not a security, and assets are not securities, and the SEC just they're trying to slow things down. They're trying to lie now. They've always been lying, but this is getting beyond a joke. Okay, guys, thanks for watching.